They called it a technical failure, a glitch, a scheduling oversight, but nobody really believed that. Courtroom 12B had been sealed for 17 years, not condemned, not closed officially, just sealed, no hearings, no public record of use. The keypad outside the heavy oak door still lit up green when pressed, but no one was assigned there, no janitors cleaned it, no security did rounds. It was listed in the courthouse system as auxiliary holding, which meant nothing. It all started with the Ralston case. In 2007, a man named Gerard Ralston stood trial for one of the most brutal and bizarre double homicides in city history. The victims were his sister and a former assistant district attorney, found together in a suburban home gutted by fire with clear signs of restraint, ritual markings, and what the original report vaguely described as non-standard mutilation. The prosecution pushed for death. Ralston pled not guilty. The defense claimed mental illness, possibly dissociative disorder. Nothing about the case made sense. No motive, no confession, and oddly, no public outrage. It was as if the city itself wanted it buried. Then came the trial. 12 jurors were selected. The presiding judge was Thomas Grams, known for being sharp, fast, and decisive. Jury selection was brief. The opening arguments began on Monday morning. By Friday, the court had collapsed, not metaphorically, literally. During jury deliberation, the building experienced a localized systems blackout affecting only Courtroom 12B lights, cameras, digital case records, all gone. The jurors never left the room. When the door was finally opened 36 hours later, it was empty, no blood, no violence, no chaos, just absence, chairs still in place. The defense table untouched. A legal pad on the judge's bench with one word written in thick black ink, sealed. No bodies, no Ralston, no jurors, no judge. The court issued a public statement citing extraordinary procedural disruption and suspended the case indefinitely. Ralston's name was removed from the inmate roster. When a reporter asked the court clerk how someone accused of 2 murders could vanish mid-trial, she responded simply, "There was no verdict." The room was locked, sealed, everyone moved on, almost. 17 years later, a junior IT technician named Malcolm Greeley was updating the courthouse network. He noticed something strange in the archive logs. Case R07120B, previously marked void, had been relabeled In Deliberation. The timestamp was current, from that morning, 4:11 a.m. Thinking it was a back-end error, Greeley flagged it for removal. But the system wouldn't let him delete it. It wasn't just locked, it was recursive. Every time he attempted to clear it, the log duplicated itself. 4 times, 8:16. Until the interface froze and rebooted with a new tag. Verdict pending, reopen Courtroom 12B. He didn't tell anyone. But the next day, the door to 12B was open. No one was officially assigned to monitor Courtroom 12B, but the courthouse's network traffic told a different story. In the weeks following the reappearance of the docket, a constant stream of untraceable queries began pinging the internal judicial database, each one searching for the same 4 terms: Ralston, jury status, verdict pending, and seal code override. These queries came from nowhere, no IP, no user ID, no terminal history. But the timestamps were exact, 3:11 a.m. every night, like a ritual. A clerk named Tasha Mayers noticed that her badge began denying her access to the 3rd floor every Monday. On paper, her clearance was intact, but her logs were auto-flagged as conflict detected. When it tried to override the block, they were met with a prompt in plain red text, proceeding in progress, external edits prohibited. That's when the courthouse printers began acting up again. Late one Thursday, as the building shut down for the night, all 14 court floor printers activated simultaneously, despite no queued jobs. Each machine printed the same document, a scan of a jury form filled out, signed in looping black ink by 12 names that matched the original 2007 panel. The box next to guilty was marked. Only one signature was missing, Juror 12. Security immediately confiscated the pages, but by morning 3 of them had already been scanned, uploaded, and anonymously posted to a closed legal forum titled Hearing the Echo. The thread title was simple: The verdict needs a host. Judge Eliza Knox never reached the bench that morning. At 7:13 a.m., her court email auto-forwarded a draft order to all relevant parties. It was unsigned but bore her court's header, her file reference, and the official seal. Subject line read, Order of Finalization, Ralston Verdict. The message body contained just one line: Let the record show this proceeding does not require consent. By the time her staff arrived, Knox's robe was draped across her chair. Her courtroom was empty, but on the center of the desk sat an old-style recording device, tape-based. It hadn't been used in nearly a decade, yet it was warm, playing. The tape looped a static-laced voice that repeated, "The court recognizes all who remain." The verdict is already in motion. Nobody claimed authorship of the file, yet that day, case R07120B was marked as concluded. The database didn't log the closure. There was no keystroke history, no administrative override, but the digital docket vanished. Entire folders were overwritten with gibberish. The backup servers labeled it corrupt exception, verdict loop. At first, it seemed like closure. The courthouse reopened 12B. It was ordinary again. Lights worked, the walls had been cleaned, the seats replaced, no trace of Ralston, no trace of the jury, not even the scorched bench remained. Courtroom 12B resumed as a civil hearing room. They even repainted the door, labeled it a new Room 312C Family Division. But on the second Tuesday after its reopening, something strange happened. The clerk assigned to Room 312C found a sealed envelope on the judge's bench. There was no name on it. Just a wax seal with an old legal scale insignia burned into it, the kind that hadn't been used since the 1970s. Inside was a blank legal pad, a black fountain pen, and a folded note that said, "One seat remains." She reported it to administration. No record was filed. The following week, a public hearing was scheduled for room 312, see a minor probate case. Low profile. As attendees filed in, the judge took her seat, shuffled papers, and began reading the case summary aloud. Then she paused. Seat 9 was occupied, not by anyone on the list, not by legal staff or public observers, just a man in gray, hands folded, a black pen in his shirt pocket. When asked to identify himself, he held up a slip of paper. It said, "I was summoned." Security was called, but by the time they arrived, he was gone. Later that night, the court server rebooted again. The docket listed a new case in 24-312C, title, State v. Unnamed Juror. Status, pending. Judge Graham's Tea Room 12B. There was no announcement, no motion, no filing, but everyone knew the trial was never meant to end. And now you were on the jury.